is systemic across the professional managerial class as a class. Then now, how do they get rich? They get rich sometimes very directly. Sometimes they're part of these foundations, or their family's part of these foundations. They're getting money. Sometimes they're like the New Mexico judge who's literally has them in their house, which raises questions what exactly he's really doing. And he went to the point of covering up evidence that this person had decapitated people. I mean, this is who they're putting in, right? This isn't the hardworking kid from, South Mexico who's just trying to help get a little bit extra money back home to his parents so they can survive. That isn't who these people are. These are people literally cutting people's heads off. These are people beating up women. These are people assaulting women. These are people assaulting kids. These are people part of the most dangerous, violent gang, arguably in the history of the world. That's who these judges are defending. That's who these judges are protecting. That's how insane they have gone. And the reaction of the left was to, oh my goodness, how could it possible? We thought judges were above the law. We thought our bureaucrats were above the law. Only Republicans are not above the law, right? I mean, that's what they thought. What did they think was going to happen when you imprison, lock up, and completely deny basic core constitutional liberties to a bunch of people who just took an unauthorized tour of the Capitol? What do you think was going to happen when you bring not one, not two, not three, but 4 indictments against the President of the United States? Did you think there was going to be no blowback? Did you think there was going to be no consequences? It's incredible. I mean, all they're doing is arresting the most egregious bad faith actors right at the moment they're committing the crime. They need to be much broader, wider, and deeper. They should see, I think what surprised some of the conservative establishment types was to see how much MAGA Trump base cheered and celebrated the arrest of these judges. Loved seeing that, like the media thought, we're going to put this big photo of this judge in her judicial robes in handcuffs coming out of the courthouse, and the whole country will now be outraged. This is fascism. This is Hitler. She's just like Anne Frank. She's just like an innocent Jewish kid that they're about to send to the Holocaust. That's who this poor judge is, defending this poor little wife-beating, abusing, illegal immigrant member of a terrorist gang. And instead, MAGA base in the large part of the country cheered, celebrated it, welcomed it, loved it, shared it, because that's where judges are, because it's where they deserve to be.
Yo, what's up, guys? I didn't hear any of the audio in the intro. I hope it did actually play. I think it did. So I don't know what's going on with my microphone today, but welcome everybody to the Rescue Michigan live stream. And for those who tuned into my previous one, I have to apologize. I got a little snippy with the audience. Folks, it's been a rough last few weeks in America with a lot of the stuff that is going on that frankly shouldn't be, and it is very frustrating. And sometimes it all gets to us. Oh, good. People say they did hear the audio, so that's good. That clip, of course, that was Viva Fry and Robert Barnes, and they're talking about these judges that have been arrested. And of course, the media is lying about that case as well. These judges were arrested for harboring illegal aliens, which is against the law, whether or not you are a judge. So, yeah. And, in the context of what we're about to talk about tonight, I think a lot more of these judges need to start being put on trial. So before we get to the show, and it's going to be probably a shortish one tonight, folks, because I am going to Grand Rapids tonight for the news conference that starts at 8 a.m. The trial begins at 8:30, so we want to be there bright and early. So I'm going to head over there tonight and take a hotel, and we'll talk about this case for the rest of the night. But you guys may have heard there is a Trump rally happening on Tuesday in Macomb County at Macomb Community College. I'm sure you can Google how to get the tickets. In fact, I went to RSVP also. But just want to let you guys know, I think we're going to have a get-together after the rally. And I found a location. So if you're interested, after the Trump rally, come on down to the Rusty Rooster Saloon, which is just down the street from the location. And yeah, we can hang out there after the Trump rally. So look forward to that. But the big topic tonight is this trial of this police officer, Christopher Schurr, which I've been trying to do everything I can to sound the alarm about this. And I want to give a big shout out to State Representative Jim DeSanta, who is he has introduced legislation. It was actually it was put in on Thursday, but it'll be read into the record on Tuesday. We'll look at that bill in a moment to strengthen the rights that you have in lawful self-defense, which is what this case is about. For those who don't know, Christopher Schurr was a Grand Rapids police officer, and this was now almost 3 years ago that he pulled over this suspect. Turns out his name was Patrick Lyoya. He is a Congolese immigrant who was driving a vehicle that the license plate did not belong to the vehicle, which is obviously grounds for a lawful traffic stop. And so he pulled the suspect over. Turns out the guy was absolutely stinking drunk. In fact, the autopsy had him at 0.29, which is more than triple the legal limit. That is absolutely blacked out, intoxicated. So he was actually a threat to the community as he was being pulled over. Like he was in the act of drunk driving when he was pulled over, and this led to a fight. We're going to watch the video. We are currently streaming on Facebook and YouTube, but I'm telling you guys, you're going to have to go over to Rumble. In fact, I will put the Rumble stream link. I'll just put it over my name right here because, or wait, what's this do? Banner. Create a banner. Can I just do this? Add banner. Here we go. Let's see what that does. Add banner. There it goes. There is the Rumble link for tonight's video because I have a feeling that Facebook and YouTube will not take kindly to me playing the video, even though it's in the public interest, even though it's on the USA Today's website, of the actual video of the incident. So you guys can judge for yourselves what happened. But I will just tell you, if you haven't seen the video, what you will see is a video of the drunken Patrick Lyoya resisting arrest again and again and again, over and over, until finally he wrestles control of the taser from the cop's hands. And only at that point, as they're rolling around on the ground in hand-to-hand combat, where the suspect now has his hands on a potentially deadly weapon. We'll talk about tasers. Only then does the officer fire his handgun once, killing Lyoya, which is what is a lawful use of self-defense. And we'll talk about, well, let's start with this point. Let's start with what self-defense law says. For those who don't know, the best resource on self-defense law is actually an attorney, Andrew Branca, who literally wrote the book, The Law of Self-Defense Principles. And he is, according to him, the only attorney in the country whose entire field of practice is self-defense cases. And he has written a book on what self-defense law is. And there's essentially at least 4 and sometimes 5 elements of a self-defense claim. And you have to have all of those in order to make a self-defense claim. And what are they? Well, the first one is innocence. You can't claim self-defense in a fight that you started. Classic example is, well, there's the case of that murderer the other day, the guy that says, touch me and find out. Touch me and see what happens. That's an invitation to a fight. At that point, you lose innocence. You have invited someone to a physical altercation, and oftentimes, when there's a fight after, a fight at the bar or something, it's a situation where the combat has been mutually agreed to. Let's take this outside. That's mutually agreeing to a fight. That is, at that point, you don't have the element of innocence. So what does that mean? Don't start the fight. The second element is imminence. And this one is often difficult because imminence can come and go in a moment. If someone is pointing a gun at you, a loaded gun at you, or a gun you can reasonably believe to be loaded, and the gun is pointed at you, that is an imminent deadly force threat. But what happens if he drops the gun? Now how imminent is the threat? If his hands are up and the gun is down, it's not imminent anymore. And so now you don't have the element of imminence. So, but imminence typically means you're in a very close quarter situation and the suspect is at the moment, in the moment, armed. So that's the second element. The third element is proportionality. And what that means is you can't shoot somebody to stop them from throwing a fist at you, typically. Now, obviously, a lot of things can easily become deadly weapons. A knife is a deadly weapon, certainly. A baseball bat can be a deadly weapon. Even arguably in certain cases, for example, a professional boxer has lethal fists to a small woman because they could kill her with a punch. That could be argued. But obviously, the issue that we have here is a taser a deadly weapon or not? And this is something that the attorney Andrew Brank has talked about, which is this. Because people think of a taser as a non-deadly weapon. It's called a less than lethal use of force. That's why they have them, is because they can use a taser if they can avoid using a gun, that kind of thing. Now, here's the issue, though. A taser is a non-lethal weapon in lawful hands. If a police officer is using a taser, then okay, they're probably not going to kill the suspect by being tased. In fact, the suspect in this case was not even fazed by the taser. However, a taser in unlawful hands that can be used to disable a police officer, can be used to take his firearm. Now a taser is potentially a deadly weapon. And it's something that an officer can reasonably assume, because they are now in a fight with the suspect who can disable him and then go on to do God knows what else. So that's proportionality. You can't shoot somebody for throwing a fist at you. You can, so all those three things together, the fourth thing is reasonableness. Would another person in the same circumstances probably take the same action, or feel like they have the right to take the same action? So, and again, this goes to the question of objectivity, of all the circumstances taken together. Would a third party view these events and say, yes, that person had a reasonable fear of his life? Or as an example, again, going back to that murder the other day with this high school student who asked the cop, so you think I got a self-defense case? He just asked the cops for legal advice because he knows he doesn't. But he wants to. This kid trying to figure out, could this actually work? If I just say, hey, I felt threatened, and of course, in that set of circumstances, which was, there's a whole bunch of other students in the room. Is this guy going to kill the other student with his fists? Not very likely. But nevertheless, the guy pulls out a knife and stabs the kid in the heart to death, which would be a murder, not a self-defense case, because, again, imminence wasn't there because the guy didn't have a deadly weapon at all. Reasonableness was not there, and proportionality was not there. You can't kill somebody for punching you. So anyway, those are the four main elements of self-defense. The fifth one, which Michigan does not have, is avoidance. And in some states, you have a duty to retreat, which is crazy if you think about it, because we just went through these other four elements. So the duty to retreat, or the absence of a stand your ground law, as it's often called, would be if you are innocent, there is an imminent deadly force threat, you can react proportionately, and everyone would see it as reasonable, but you could still be convicted because you maybe could have retreated in the mind of a jury. That's how crazy that duty to retreat principle is. But that's what it often is. It will not often, but in some states it is. It's the law in several states. Don't go to Democrat states, folks. But when people talk about stand your ground laws and act like that just means you can shoot somebody for no reason, no, that is not what those mean at all. And everyone lies about it because the left lies about everything. Stand your ground simply means that one element of self-defense isn't there. That one requirement. But there's still the other four. You still have to be innocent. The threat still has to be imminent. The reaction still has to be proportionate. And all things considered, it all has to be reasonable. Gritter Dunn on Rumble says, Kent County prosecutor will not prosecute pedophiles distributing porn to minors in our schools, but will prosecute a policeman protecting the community and himself. Yes. Chris Becker is disgraceful. And shame on any voter that would vote for him. Now, it's a problem in Grand Rapids because he is nominally a Republican. So what do you do? And again, see my previous remarks and other streams about the importance of not voting for the lesser of two evils. You might get stuck with a Democrat prosecutor, but maybe someday you can have a Republican prosecutor again who's not really a Republican in name only, like this guy Becker is. But anyway, before we go to the video, because the video is going to be the big part of the stream, I do want to show you, we have the bill as introduced by Representative DeSanta. It will officially be posted, I think, on Tuesday, but I can share it with you because I have it. This is the draft, and this is well, this is the draft, but it's going to be introduced in the same form. We are also working on another bill to address criminal penalties. So what this bill does is protection from civil liability, because in addition to the criminal charges, Officer Schurr is also being sued by the Loyola family for $100 million. So this is the bill that we came up with, and here's what it says. The language that's not in bold is the existing current state of the law, and the stuff that's in bold is all new language. So an individual who uses deadly force or force other than deadly force in self-defense or in defense of another individual in compliance with Section 2 of the Self-Defense Act, or who threatens to use deadly force or force other than deadly force in self-defense, is immune from civil liability for damages, including but not limited to damages for personal injury or death caused to either of the following by and this is excluded now because it's being made a lot broader. So here's what the new language says. In an action in which an immunity defense under this section is asserted, there is a presumption that the individual claiming the defense is immune if any of the following apply. One, it says A, but I'm going to say one. A grand jury or judicial officer acting in the capacity of a grand juror has declined to indict the individual for the use or threatened use of force or other than deadly. So if they decline to bring charges, and same thing here with this one, if a prosecutor has declined to bring charges, or the magistrate refuses to issue a warrant or summons against the individual because they don't even believe that there is even a probable cause, a preponderance of evidence that you're guilty. Or if you've been discharged by a court after preliminary examination in a case charging the individual with the use of deadly threatened force. Or a criminal charge against the individual for an offense involving the use of force resulted in acquittal of the individual, not guilty verdict, or dismissal of the charge. So basically, you can't be sued for damages arising from self-defense if you weren't even charged with using force. Which is what, of course, otherwise these would be. It might be a murder, it might be a manslaughter, an assault or battery, whatever it is. And the court shall award the payment of actual attorney's fees, court costs, lost income, and other expenses to individual who is sued for civil damage. So the sad thing is, obviously, this is not going to be signed into law by Gretchen Whitmer in time to protect Christopher Schurr. But we're going to have a news conference about this bill tomorrow, protecting the right of self-defense, law-abiding self-defense, because it will become a story in itself. We're going to be at the courthouse speaking out about this and protecting the rights of individuals. Now, we have another bill in the works on the criminal side, too, which what that bill would say, and hopefully we'll get it out the door pretty soon here, what that bill will say is that if a case goes to a jury and the defendant asserts self-defense, which again, I mean, there's the guilt beyond a reasonable doubt, but you still have to establish beyond a reasonable doubt, in a sense, on all four of those elements of a self-defense claim. Plus, by the way, keep in mind also, if you're arguing self-defense, you have to essentially admit to having used the force in the first place. So any number of other potential defenses, you can't use anymore. You're kind of admitting to doing the thing. So a self-defense claim is hard to prove. But what we would say is if you are charged with self-defense, and you are acquitted of self-defense, the judge also gives the jury an instruction to find whether they believe there was even a preponderance of evidence that you were guilty. And if not, then you are entitled to recover attorney fees from the government. So that the taxpayers actually, the prosecutor actually loses, because this guy's life has been ruined already. He will be in debt to the lawyers for the rest of his life. I think he might have representation as from the police union, but he probably doesn't. Or there's probably going to be some way they're going to try to take that away from him. But the bottom line, folks, is if you are tried for murder, your life is over. Even if you're acquitted, you are still going to be buried in legal fees for the rest of your life. You're still going to have to look over his shoulder for the rest of his life too, because you have these race grifters agitating. I mean, what they are trying to do is effectively a lynching. I mean, let's make no mistake about this. They would kill him if they could. They would kill him if they could. I don't think we're being hyperbolic or exaggerating saying that this is an attempted lynching by the radical left, and this prosecutor is in on it, frankly, as are these judges, because they should have never allowed this case to go to trial for the reasons that we're going to see. But the basic element is this: The facts of the case are not what's in dispute. A jury is supposed to be a finder of fact, not an interpreter of law. Typically, the judge, who's supposed to be the expert in the law, and will be briefed by both of the parties, they'll go back and forth, they'll argue about jury instructions and things of that nature. And what the judge is supposed to say to the jury is, okay, if you find X in the facts, then you should do Y. Because the jurors are equipped to determine facts. They're not necessarily equipped to determine law. I just went through a bunch of self-defense law with you guys. Most people don't know any of those things. So the question is not what happened here. That's all on video. We're going to watch the video. The question is, who should be determining then, based on the undisputed facts of the case, whether or not this was self-defense? Well, a judge should be able to apply the law and say, well, okay, clearly the police officer was innocent because he was assaulted by the perpetrator. Was it proportionate? Yes, because the perpetrator was armed with a deadly weapon. Was it reasonable? Yes, because a reasonable person would be concerned that a fleeing felon who is drunk as a skunk with a taser in his hands might be a deadly force threat. And they are, in fact, in close quarter combat on the ground fighting for control of a deadly weapon. And that's pretty much the analysis there. No probable cause, no trial. He should have been let go right then and there. But the judges go, well, let's let the jury decide all those things, even though it's all on the tape. And why did they do that? Because BLM is in their faces, and they're too cowardly to do anything about that. It's disgusting. In fact, there are billboards all over Grand Rapids right now saying to convict this guy, which in their minds means put him in prison for the rest of his life, and hopefully he'll be murdered by an inmate in prison because he's a cop in prison, you know? That's what they want to do. And they want to brag about it. They want to take his scalp, like they took the scalp of, help me out, chat. The guy in Minneapolis, Derek Chauvin. This is what they want to do. Chris Christie says, I couldn't get Rescue Michigan live on Rumble, so I came back to YouTube. Well, I'm sorry to hear that, Chris, because you're going to miss the rest of this video. But there is the link at the bottom of the screen right there. It's all lowercase, and it is a little cumbersome to type, unfortunately, but that's just the way that goes, unfortunately. But, yeah, that's the way it is. Algan News says all pew are assumed to be loaded. Yes, because why wouldn't they be? If someone's got a firearm, it's, you know, doesn't do any good if it's not loaded. Mark S. Price says Jim DeSantis is awesome. I agree. Trump is the greatest. I largely agree, although we might talk about some things he's been saying this past week. Government sucks. I agree. Anarchy is awesome. Well, this is anarchy, Mark. This is what the radical left wants, and not the kind of anarchy I want. I want rule of law. The government does have one job, and that is to protect innocent people from violent criminals, in my opinion. Mark says, it is my great hope that the next governor of my beloved state of Michigan would be a Trump supporter. I hope so, too. I hope somebody runs who is. Just saying. All right, we look at the bill. So here's, I guess, one of the last big things about the case before we go to the video. This is what happened way back in 2023. This has now gone through Court of Appeals and the Michigan Supreme Court. All of these judges have done the wrong thing and failed to dismiss the case. You can see here what they said. So Judge Christina Elmore, her name now is Christina Mims. By the way, I will be doing my best to live stream the entire case. The trial is Monday through Friday. They say it's going to take as much as 2 weeks. However, tomorrow I will be in Grand Rapids, so I don't think I'll be able to stream the first day. So I don't know how we're going to do that. Maybe I'll be able to catch a feed of it someplace and do like a delayed version of that or something. I don't know. But we'll try to have ongoing coverage of this case. They say he's been charged with second-degree murder in the shooting death of Leoya. And by the way, every single news media story about this case has been false. So here we say, or at least misleading. So shooting Leoya in the back of the head, which of course it implies like he was running away and the cop just shot him in the back of the head. Not the case at all. Not because they were locked in deadly combat and the guy's face was like, you know, you'll see the video. Their flesh is pressed together. Anyway, so as the guy's attorney says, he followed policy and training every step of the way. They argued that Michigan law permitted him to use deadly force against a leader who was fleeing. Not just fleeing, but in fact confronting him. I wonder if they didn't make the wrong argument here. But we'll see on the video. So this judge, Nicholas Ayub, should have dismissed the case. He refused to and bound over the case for circuit court, saying, again, a jury should decide what the video facts say. So in case they want to disagree with the facts on the record or ignore what the law says, which is what they're hoping for. Anyway.
And the trial is expected to last 2 to 3 weeks.
All right, I'm going to close that window because it suddenly started making noise. And we can now go to the video. Hold on. I got to move some things around here. Let me put this up here. By the way, one thing I also mentioned, even that bill that Representative DeSantis is putting in, even better than a law that Texas is considering, a similar law. This one covers more types of harm, includes threats, better cost recovery, more ways to get immunity. So it's actually even a stronger version than the one Texas is considering. So that's pretty cool. Anyway, let me get this screen share going, and then we're going to have to say goodbye to the folks on YouTube and Facebook because I don't want to get my channel nuked. And that could happen, even though, as you can see here, this website, it says at usatoday.com. So it's not like, it's not like this is on like some kind of illicit website. But unfortunately, folks, if you are watching on Facebook or YouTube, I want to say goodnight. So you can copy that link down below, rumble.com/V is in Victor 6 SNVO9 -the lynching of Christopher Schurr SCHURR.html, and there it is. So all right, guys, good luck to you finding the stream over there. Until next time, we'll be back streaming probably on Tuesday, maybe even sooner. I don't know. Until then, good night to you folks on goodbye on the folks on Facebook. And there we go. And now we're going to have to say goodbye to the folks on